Hi guys, it's Kathy. I hope you're doing well. We made it to Saturday. Yes. Um, we're gonna do Judge Johnson, Judge Eric Johnson for a while. I got his docket, and it might take us a day or two to finish. He has longer cases. He had longer cases. Was it yesterday? Yes, it was from yesterday. It was. So hopefully there's some good ones. I know there's some that make him ponder. So we're gonna see that. Let's go. I started it here, which is a little bit into one of the hearings. I think a victim is speaking right now.
Bad intentions towards him or his family or even towards this whole incident. I just want some justice and to resolve some type of peace from it all.
What do you mean that things got physical?
When Lexus had called him and I wasn't aware that he was upstairs. I know that Lexus had called her friend Gigi and she was on her way to come get her. So we have we have sheets hanging up from the pillars from downstairs, so we can like section off like walls. And she and Gigi were picking up some of her shoe boxes and bags of clothes and going upstairs. And I was getting the rest of her stuff as well. And I just looked over and I saw him walking down the stairs to the area of where they were getting her shoe boxes. And uh, he had said, "What's up with the that altercation we had had in the past, which was with his sister's baby daddy?" And I said, now's not the time, whatever, whatnot. And he's like, "Oh well, I got plenty of time." So I engaged, and as he approached me, I approached him. He was egging me on, like getting in my face. So, I fed into it and I slapped him. He immediately reached for his hip. So, I didn't think to like jump on him or, you know, rush him. I just thought, the first thing to do was just to try to run and get away. And there was really nowhere to run. So I was trapped and cornered and uh, gunned down, shot two times out of the four. And he left, was running up the stairs and was yelling for Gigi to come on. Gigi looked and stood over me and was crying and telling Alexis that she was sorry. And and I had told Alexis to call 911 to get him on the phone because I wasn't for sure, where I was hit or if it was like the main artery or something. But I did have her call 911 immediately.
Thank you very much. Is there anything else you'd like me to know?
Um, no, that's it.
All right, and so let's see. I'll mute Mr. Joseph Grin. Um, let's see, Rachel Grin. What would you? Whoops. Oh, there it goes. What would you like me to know?
I would like you to know, at that time, I was foster caring for the children that were in my home. We were at the store grocery shopping when I got the phone call that my son had been shot in the basement. I was fostering. We had an open case with the Department of Human Services. for 4 of the children that I now have currently adopted. I had 5 of the children in the home, but due to the situation, my grandson, who I was also going to adopt, was taken away from me a year and a half ago because of the madness that was going on and, um, just the negativity. The father felt like, due to the circumstances of the gun play, he didn't want his child in my home where he didn't feel safe. That was the right thing to do, and I had to give up my grandson. It's been almost 2 years now. Joseph was not allowed to come home, even though he was the victim in the situation. I wasn't allowed to have my child step into my home, or the children would have been removed. As we stated before, we had uh, 4 of the children were home, aging from 12 to 3. Um, the babysitter was here, and I've almost lost my children, almost lost my son's life. I'm following pretty much Joseph's footsteps of forgiveness of the situation. But at the end of the day, if your intentions are to come over here and fight, there should have never been weapons. And there should never been a fight. He wasn't invited into my house, nor was his girlfriend. Alexis didn't even have the authority to invite them into my house to help her get her stuff. They could have waited outside in the back, and as Joseph was bringing the stuff up, they could have been getting it off the back porch. So I just want Matthew to know that I really did not appreciate the fact that you did not stop to think of your surroundings or anything else that could have transpired besides taking my son's life. There were little children upstairs that bullets could have ricocheted from the basement, could have came upstairs, hit any one of my children that were innocent, that were not a part of anything that you got going on, who has also, I have the children, Your Honor, due to violence. They have grown up in a world of violence. Mother's violence, her spouse's violence, they've grown up as human punching bags for monsters. And then they have to endure what they have to endure with their uncle being shot in our basement when they're home.
All right, thank you very much. Anything else, Mr. Walton?
Nothing further from the people.
Barry?
Thank you, Your Honor. I'm going to start, and then we also do have a few people who'd like to speak on Mr. Velasquez's behalf.
All right, keeping in mind that I have read completely, twice, not only your sentencing memorandum, but the report of the social worker.
Understood. I will keep it brief, but I do think that, I wasn't going to speak too much as to the events of that day, but since it's been brought up many times, I think it is worth noting. Mr. Velasquez is also not a stranger to being raised in a home with violence. He watched his mother be abused by his father almost daily as part of his childhood. Getting called into the home by
Thank you,
Alexis
Kelly. Thank
to
you.
help her move
Thank you
out
for the
after a
bits.
situation where she experienced domestic violence, combined with Matthew's diagnosis for autism, did
Monica,
lead
thank
to
you for
a
the bits.
situation
Thank
that I
you.
know he regrets. He was hyper vigilant, hyper aware, and when he was slapped by Mr. Grin, it did lead to the situation that we're in today. Your Honor, I would note for the court, since it hasn't been stated yet, this is Mr. Velasquez's first contact with the criminal system. This is his only conviction that he has on his entire record. He was 19 on the date of this incident and is now 21. And since being out of custody, there was only one pretrial services complaint that was filed that ended up being withdrawn. And he has had otherwise perfect, I suppose, attendance. I don't know how else, perfect compliance with pretrial services. Your Honor, we are asking that the court give Matthew a chance at probation. He is the exact type of defendant that probation has been designed for. He is young. Science has shown that he's more amenable to treatment than people who are older than him. At the time of this incident, I know that the court has mentioned that they've read my motion, and so I won't harp on it, but his brain development was not where a fully developed person's brain was at the time of the incident. That combined with his mental health history does make Matthew less culpable than your average defendant. I can say that what I didn't include in this report is that it has been a pleasure to represent Matthew. He is a kind young man. I don't go to many of my.
Okay. Yeah, his brain isn't fully developed yet, which means he tries to hang on the curtain rod in the bathroom. It doesn't mean he shoots someone. It means he gets his head stuck somewhere. It doesn't mean he shoots someone. That's not, the brain isn't fully developed type of activities. That is just not. He sounds like he shot someone, a kid.
My clients' homes, but I have been to Matthew's home a number of times. He is responsible for a lot in his community. He takes care of the younger children in his house. He takes care of many dogs. He also has, I think, 2 jobs right now that he juggles on top of having this open case. His house is very clean, and he keeps it clean, and he offered to cook for us and, give us, tea and everything whenever we'd come over to his house. He's just a good kid. He has proven time and again that a community-based sentence is appropriate. And he knows that if he is not successful in a community-based sentence, that he will be going to prison, and that will be a minimum of 5 years. Your Honor, we would ask that the court impose probation in this case, and I will turn the floor over to Camille Ponzarella, who is our social worker at this time.
Morning.
Good morning. My name is
Keep in mind I've read
yeah.
the report.
My name is Camille Panzarella, and I'm a licensed social worker with the Colorado State Public Defender Office. I was assigned to Matthew's defense team in January of this year to collect mitigation and write the report that was filed with the court.
Are you now an actual social worker? You were a candidate before.
I was an intern at the Denver office. I now work at the Arapahoe office.
Congratulations.
Thank you. From our very first meeting, it was clear to our team that Matthew would need a different approach and a higher level of support. His diagnoses of autism and dyslexia make it a lot harder for him to process information, regulate his emotions, and express what he's feeling. Mitigation is deeply personal work. It's my job to dig into someone's entire life, including their mental health, trauma, substance use, moments of resilience, and overall the circumstances that shaped who they are. That process can feel overwhelming for anyone, but especially for someone like him. People with autism often become dysregulated in high-stress environments where too much stimulation and unpredictability can shut them down. Matthew had voiced to us from the very beginning he has a difficult time explaining things and getting the right words out. So instead of forcing him into unfamiliar settings, we decided to have our visits with Matthew in his own space, where he felt safer and more grounded. After months of meeting with Matthew to learn about his background, I finally completed the written mitigation report and went over to his home to share it with him. We agreed that I would read it out loud to him due to his dyslexia that impacts his reading ability. That day, we spent almost an hour together as I read through the 13-page report detailing his life. I remember getting through the first 2 sections and looking back up at Matthew as tears filled his eyes and fell down his face. We took breaks while reading the rest of the report to give him space to reflect. At the end, we debriefed. Matthew explained how tough it was to hear about his life and what he had been through, but he expressed finally feeling validated, that his pain was real and that it had a profound impact on his development. This awareness helped him reconnect with fragmented parts of his story, offering clarity not just about his own life, but also about how his actions have affected others. Through our conversations, he has expressed sincere remorse for the harm he's caused. He recognizes the depth of the pain he inflicted, and he takes accountability, not just by acknowledging his wrongdoing, but also committing to change and healing. There are certain clients who stay with you long after your time working together ends, and Matthew is one of them. His gentleness, quiet strength, and the unique perspective he brought to our interactions have left a lasting impact on me. Through working with him, I learned the true meaning of patience and witnessed firsthand what resilience can look like in its most genuine form.
This judge is going to get him. What do you think? I don't know, but I think this judge is about to get him.
He challenged me to slow down, listen differently, and meet someone exactly where they are. Matthew's impact continues to influence my growth and shape the way I engage in my work as a social worker and advocate. You can't understand most of the important things from a distance. You have to get close. I respectfully ask that you look beyond the surface and get close to the full story of Matthew as a whole person. Recognize the humanity behind the offense, the pain he has endured, the resilience he has shown, and the profound challenges that have shaped him. But most importantly, see a sincere commitment to healing, building a new, positive future for himself. Thank you.
All right, thank you.
And then, Your Honor, I think finally Matthew's mother would like to make a statement.
Hi, good afternoon. What's your name?
Keisha Velasquez.
What would you like me to know?
Just that Matthew's a good kid, you know, he's gone through a lot and he does feel bad for what had happened. He comes to me, tells me all the time that, you know, his actions affected everybody around him and he does feel bad for what he does, but he is a big part of our family. He helps me. I work overnight, so he helps me with his little brothers. And, you know, he does do a lot for our family with support because I am a single mother. So he does help me a lot. And I just hope that you look at his self and know that he is sorry for what he did.
Thank you. Appreciate that.
Thank you.
Sir?
Your Honor, I have nothing additional to add at this time, unless the court has specific questions for defense.
And Mr. Walton, I'm sorry, you said no restitution, right?
That's correct.
All right, Mr. Velasquez, you have the right to tell me anything you'd like me to know.
I just want to tell you it's been a pleasure being in your courtroom, and I've grown a lot since this incident, and I just want you to just know that I don't want to be far and separated from my little brothers and my family. Those are the people I love the most. My little brothers, they give me a lot of courage. They make me fight. They push me. I just want to say thank you, and I appreciate everything you've done. That's it.
I just want to tell you what would be best for me, Judge. That's it.
The attorneys in here have heard me say it 100 times, but sentencing is my least favorite part of this job.
Oh, he's getting nailed. Oh.
It's hard. I've got no crystal ball. And, you know, to your mother, to everyone else who wrote letters on your behalf, to Miss Panzarella, I always look at the people in front of me as complete human beings.
Oh, okay. He just said two different things there. Now we have to guess which way he's going. I always hate sentencing. Boom, he's about to nail him. He's about to nail him. I look at people as human beings. He's about to not nail him. So which one is it, Judge? I think he's about to nail him.
And I know nobody who's in front of me, this isn't about are they a good person or a bad person. About what happened on a day at a time. That's all I can focus on. So this, you very well may be, as was said, a good kid. You're not a kid. You weren't a kid on the date of offense. 19-year-old is an adult. In all of the brain science, I accept. A hard thing to know, though, is what to do with it. Impulsivity, control, et cetera, et cetera, et cetera. On the other hand, you made it 19 years without ever doing anything. So apparently the impulsivity control is not that big of an issue. But the science is what the science is. How to weigh that against this wasn't a situation in which you were suddenly overwhelmed. This is a situation that you did not go into that house to help someone. You went into that house armed with a gun, and you went directly for the person you knew you have a beef with, and you were immediately confrontational. You started the confrontation. You got slapped, which I get can be demeaning. And your response was a dominance response. Okay, bitch. Trying to put that person in their place and pulling out a gun and shooting them. So this isn't a situation where an autistic person is suddenly overwhelmed. This is something that you inserted yourself into and you started and you did. All of which is also complicated by your past, and no person, judges included, can read your history and not be moved as a human being. Question is, as a judge, somebody who has been given the responsibility to enforce a social contract so that this family doesn't go out after you and just gun you down in revenge. They cede that right to the state because they expect the police to investigate. They expect their case to be assigned a prosecutor to prosecute the case, and they expect a judge, if the person is found guilty or pleads guilty, to exact some level of justice. And what does that mean? I can't unshoot your victim. I can't give him, can't get rid of his nightmares. I can't get rid of the nightmares of the kids who had to sit there and experience what you put them through. And so, yeah, sentencing's hard. I've got kids your age. I can't look at you and not think of my kids. You know, and you say you don't want to be separated from your family doesn't want to be separated from you, and at some level, kind of reminds me of an old quote by, there was a football
Brian
coach
Oakley.
named Lou Holtz. He used to be a coach for Notre Dame, and as Notre Dame football players run out of their locker room, there's words painted over the door as they go onto the field. It says, "Play like a champion today." And as they go out, they all hit that. And Lou Holtz
Hold that
noted
thought, Judge. Hold that
that
thought.
everybody want.
Peg leg walked in, Judge. That means you shut up. There are rules to my chat. All right, you are background noise. Chat is front and center. Peg leg. If you get arrested or in trouble at all, I'm gonna talk the judge into making your sentence be you have to represent him for a case. just one case. Oh man, Peg leg, we would love to see you in action. You should record one of your, even if it doesn't have to be criminal. You should record so that we can watch you. If you do that, I will play it twice. All right, back to work. Back to this guy getting nailed.
It's to be a champion, but not everyone's willing to do what it takes to be a champion. Nobody wants to be separated from their family, but are you willing to do what it takes not to be separated from your family?
I could
This
leave my
isn't on
family.
me.
I'll
No matter
leave.
what happens, this is not on me. Yes, the responsibility falls to me, but it's your actions. Are you doing what it takes to be where you want to be? The answer on that day, at least, was no. You've come a long way since facing a mandatory 16 to 48 on an attempted murder. And for everybody who cast dispersions at prosecutors in the system, I think you and everyone should appreciate the actions of the Office of the District Attorney to realize that when they were confronted with certain evidence, they acknowledged that certain charges were not viable and reassessed the case such that you are to a point where you're at a probation eligible 5 to 16. That's how the system is supposed to work, with good defense attorneys doing their job on your behalf and good prosecutors, ethical prosecutors doing their job. So this is a situation in which it worked, but you've come a long way from a mandatory 16 to 48 to a probation eligible 5 to 16.
He's already done 2.
In the end, I don't, capital J, judge you as a human being. And in the end, I don't have, like I said, to begin with, a crystal ball. I think a lot of judges think that they're really good at knowing who's lying to them and who's not, who's serious and who's not, who's going to recidivate and who isn't. The science tells us they're not. The science says judges are no better at that than anybody else. But I got no idea whether you're sorry for today, whether you're sorry that you're here, or whether you're sorry for what you did. Final concept, final thought on sorry. Sorry does not get you out of punishments. Truly being sorry for what you did and a true apology means you're going to accept responsibility for.
He didn't really say hardly that he was sorry. He said that he didn't want to go to jail.
Your actions. And you're not going to repeat them in the future. That's what being sorry means.
Guys, why is there a golden Spanish statue in the court?
I agree with the victims that
It's
and
George
with the DA
Washington.
and your
That statue is George Washington. Yep, it is.
attorneys. Well, we have a range of 5 to 16. So what's a 5-year shooting someone in the leg, and what's a 16-year shooting someone multiple times in the leg? The 16-year is someone with a criminal history or something incredibly aggravated. Well, you don't have a criminal history. And I'm afraid walking into a place not with good intentions, armed, and immediately picking a fight is somewhat aggravated.
Hanky Panky, what state are you in? I'm going to try to get you judges.
On balance, all things considered, I am going to sentence you to the Department of Corrections because when you shoot another human being, you simply cannot expect probation. You shot a human being. And our society cannot tolerate that.
Jorge
So I am going to
Washingtino.
sentence you to prison for 5 years. I will note the 230 days of pre-sentence confinement credit, and I will note the 3-year period of mandatory parole. Now,
Hi, Terry.
you do have, in certain instances, a right to appellate review within 49 days under Colorado Appellate Rule 4. And now this part is important. This part is important. You have the right to ask for post-conviction reduction in sentence within 126 days. Your attorneys will continue to work with you, and I'm sure I am going to be getting a motion under 35B asking me to reconsider. But you simply, having shot someone,
already in
cannot
your
expect to walk
inbox.
out the back door of this courtroom onto a straight probationary sentence. You have my empathy for what you have gone through in life, but what you did on that day at that time has earned this sentence. I'll note no pecuniary loss, no restitution. Anything else from the prosecution?
Nothing further.
Anything else from the defense?
Not at this time, Your Honor.
All right, I'll wait for your motion.
If I was his mom, I would be that upset too.
That'll conclude this case.
If
Your Honor,
Anthony did that.
just one thing I did speak to Mr. Velasquez about, he does have 2 funerals in the next 10 days. I know that on a prison sentence, remands are very,
I am not going to consider anything other than every time I let someone try to turn themselves in later, they don't show up, and then I've got to give them more prison. I'm not doing it. You were here for sentencing today. You're being remanded today.
okay, I'm gonna put this, can I put this in his pocket? Okay, I'm gonna put this right here.
Yep, there's his mom. Yep, I would be the same way. If it's a YouTube judge, I probably won't be introduced to it. Like, I want to see you though.
Yeah, I can set one. We can bring it in. Everybody will be in custody. Yeah,
He has a long, huge docket
I'll look
today
at it.
with heavy cases. He
Counsel.
went till
Yeah, and I'm ready to call Miss Alicia Cruz, who is number 15 on the docket.
8 or 8:30 Eastern Standard Time. This is Colorado. So it's Central Mountain. It's Mountain. I don't know why. For me, if it's not Eastern Standard Time, everyone else is Central. I have to force myself to think of someone other than Eastern or Central. So no, he's Mountain Time. So he went past 6 o'clock on his docket today with this one, and we're going to watch it all.
All right, 19 CR
Utah?
241, People versus Cruz entries.
Anthony Santos for the people.
And Mike Orlando on behalf of Miss Cruz, who appears in custody to my left.
That means you're Central, Salty. I'm Eastern, you're Central.
All right, here for another revocation, appearance on warrant. We'll appoint the Office of the Public Defender. Entries.
Anthony Santos for the people.
And Mike Orlando on behalf of Miss Cruz.
JK,
who
you're
appears in custody
Central.
to my left.
Go ahead, counsel.
Your Honor, we are requesting to address bond today.
Have you advised your client as to the complaint?
Yes, Your Honor.
Do you waive further reading and advisal?
Yes, Your Honor.
Central.
All right, well, there is a complaint to revoke probation that has been filed. You were on probation for a Class 1 misdemeanor. I put you on probation on March of 2025. The allegation is by May of 2025. Less than 2 months later, you simply stopped reporting. We'll enter a denial to that. Set a
Bars-
hearing on
bars are closed,
revocation of
Dalty.
probation for September 26th at 11:30. What's your argument on bond?
Your Honor, we are requesting a personal recognizance bond before. In speaking with Ms. Cruz, this is the first time that she has ever been on probation, and she really wants to be given the opportunity to demonstrate to the court and to herself that she can turn the ship around and get into compliance with probation. When she was on probation in this case, she was kicked out of the home that she was living in and ended up going to live in her car. Since then, she has been trying to turn her life around, and through her cleaning business that she owns, she's been trying to save up money to begin renting a room with a friend. She's hopeful that if she is able to get out of custody on a personal recognizance bond, she will be able to start renting that room and then start making progress on probation. Additionally, since the probation complaint was filed, she has been able to resolve a few of her old some of her old municipal cases and is looking to shortly resolve her case in Arapahoe. Since all of these cases predate her sentencing in their case, they are not new law violations in this case, but she is looking to resolve them in order to get her life together. Ms. Cruz is ultimately looking for the opportunity to demonstrate that she can be in compliance with probation, and we do believe that would be the best outcome for her if she was given a personal recognizance bond and able to be given the opportunity to demonstrate that.
Prosecution?
So, Your Honor, I actually struggle with this one. You know, if this had just been a couple months, then I would be sitting here saying, I think a PR bond is a great idea. Let's do it. My hesitancy comes in the fact this is a 19 CR case. From 2020 to 2024, Ms. Cruz was in the wind. I don't think that just a jail sentence is going to help her. I would rather her be on probation, but obviously the history of this case and her demonstrated history gives me pause, and obviously should give the court pause as to her ability to be on probation. This is an M1. I think, again, probation would be the best case scenario for Ms. Cruz, getting her life kind of stable and back in order. I know that she's being held also on another case as well. So I think a PR bond would satisfy the hold in this case. Obviously, she would have to deal with whatever's going on in Arapahoe before she could report to probation. Frankly, I don't know what the right move is in this situation. I worry that a PR bond is going to cause Ms. Cruz to flee. But at the same time, she's sitting here telling us that she wants to be on probation. She wants to show and demonstrate her ability to do so. So at this point, Your Honor, as far as a change in bond, I would defer to the court on that. I have my concerns, but I also have the fact that she's standing here saying that she wants to be on probation. And obviously, I think that that would be best case scenario for her if she was able to successfully complete probation, overcome any addiction. But that means that she would actually have to do the substance abuse evaluation, which she hasn't done. So all of those things conflicting together, I'm hopeful, or I think that it's commendable that she wants to continue to be on probation. But as far as a bond at this point, I would defer to the court.
All right, well, my mind on this is pretty clear. You're not entitled to a bond on a probation revocation. Yet I set a $500 cash bond, and I'm not lowering it to a PR bond. You failed to appear in that case in Arapahoe that everyone's talking about. You simply stopped reporting in this case. This wasn't a situation of, well, this is hard, but I'm contacting, this is hard, but I'm doing something. You did nothing except also blow off Arapahoe County and failed to appear, and you've got yourself a bond set in that case as well. The bottom line is the reason in cases that I don't set bond is because I don't think the question for the court is probation appropriate? And in your case, probation is not appropriate again. This is a DM1. You completely blew it off. And well, we'll see. I don't know. We'll see what happens at the hearing. We'll see what happens, whether you get credit for taking responsibility. We'll see what happens. But in all, looking at a case like this, my disposition is that my inclination is that probation is not appropriate. We'll see if you guys can change my mind on that, but I've set I'm not going to change the bond. I've got your revocation hearing set for the 26th at 11:30, and we'll go from there.
Thank you, Your Honor.
Judge Salty. Yes, Joe,
Your Honor,
you're
could we
right.
please call Florian Eswe? Number 2 on the docket. Whoops, sorry.
I'm sorry, you said this was who?
Florian Eswe, number 2 on the docket.
Thank you.
Yes.
Pardon me. Twenty CR 352, People versus Eswe entries.
Morning, Your Honor. Dan Breckbuell with the Colorado Attorney General's Office on behalf of the people.
Good to see you again, sir. It's been years.
Michelle Wolf appearing for Chloe Gleichman on behalf of Mr. Eswe, who appears in person out of custody.
And just so that you all know, Mr. Breckbuell and I were district attorneys together in Adams County previous lifetimes ago. We do not have a social relationship.
Oh, Kelly. Kelly, I am so sorry. Oh my goodness gracious. How old was he? Come into Discord and talk if you need to. Please come into Discord and talk. Please. You can talk for days and days and days.
Relationship and haven't had one since we stopped being DAs together 30 years ago, but we did work together.
I would object to the 30 years comment, but it's somewhere around there.
All right, the reason I wanted everyone here today is I don't think I could do this on paper. I think the defense is making certain arguments and representations as to ability to pay that require more than just conclusory statements and emotion.
Understood, Your Honor.
I'm not sure that the continuance is warranted. Because if zero has been paid, he will not be paying $127,000 in the next 180 days. If he's paid $100,000 and we're
I
talking,
am prepared to address that.
all right, well, I'm trying to lay out what my concerns were so you can address them all at once without me having to drip them at you one at a time.
Understood.
And then finally, on this issue, I will not have Mr. Eswi appearing remotely for any of these findings because of the potential actions that the court may have to be taking, will have at its disposal. Anyhow, between y'all, who wants to speak first?
Your Honor, I think the defense can go first. The Attorney General's office is not objecting to the request to continue probation for 182 days. I understand that the court set this hearing to determine whether Mr. Eswi did have the future ability to pay in order to grant that request. So I wanted to alert the court that Mr. Eswi had been saving up for a lump sum payment, which now has been made in the amount of $20,000. I do have the receipt for that, but that was paid this week.
That's a disappointing number.
I understand that, Your Honor. I do have further argument to make about his future ability to pay. I know that 20,000 on 127,000 is a disappointing number. However, since Mr. Eswi was placed on this probation, ultimately, he had to completely pivot in terms of his career. He has a PhD, but because of these charges, his reputation was essentially destroyed, which he understands, which is why he has been using this time to try to reinvent himself in order to be able to pay this restitution. He has established a publishing company and is now a published author, and he is developing book writing workshops, book tours, trainings, and conferences. He's also creating digital products such as courses and ebooks that will provide sustainable sources of income so that he can pay this restitution. He is also working with family and close friends to raise additional funds to pay off the restitution. Like I said, he was able to make that $20,000 payment a couple of days ago, and those came from proceeds from his book sales. It's my understanding that the friends and family that he's been speaking with are talking about taking money out of 401ks to help him make these payments in this time. But also he is really on the right path to making an income that will allow him to be able to pay this restitution that he's been unable to pay thus far.
Your Honor, it is concerning that it has taken this long, but on the other hand, at least he has made some payment towards it. He doesn't, in terms of there's no new law violations. It's only this restitution part. There seems to be some promising things that are happening. Hopeful that will come through and he'll be able to pay all the restitution. We'd have no objection if the court were to extend the deferred judgment. What I calculated was March 16th, 2026. Might be off on a couple of days on that, but that seemed to, so I'd ask the court to allow the deferred judgment and sentencing to be continued to that date. Maybe we could set it for another hearing, like the week before or something, kind of see where we're at that point. That'd be our request, Your Honor.
I wonder if he's published anybody else or just himself. Calm down. He's pondering. It's okay to have silence.
Well, I've got serious concerns because we spoke long and hard before I even accepted this disposition. My notes indicate I just said that there's no way he's going to pay this. And I was assured by you that this was, quote, no problem. And here we are 4 years later, and apparently it's a 4/5 problem.
I've been published in 13 books on coding now.
Mr. Azui, I don't think it's any surprise to you that I very much hate theft cases like this. Cases like this aren't based on some sort of drug addiction or anything else. This is just pure, unadulterated, old school greed. And the fact that you've waited 4 years and only made a paltry $20,000 payment is incredibly dissatisfying. I'm not your father. I'm not going to start setting status hearings. You're either going to do what it takes to get it done, or this is going to go to a hearing on a revocation, and I am going to make findings. And my guess is over the last 4 years, you've been underemployed or not doing what you could do to pay more. And I don't say that because I'm prejudging the case. I'm saying that because I'm been around this world about as long as you have, and I've seen some things, and I've got a really good idea of what the evidence is going to end up showing. And if the evidence turns out the way I think it probably turns out, you are now fully aware of how much I despise these types of greed-based theft cases, and you can imagine what my response to a revocation might be. Do you need me to be more explicit?
Do you understand that you don't just send you to prison?
Yes. Yes.
No, he-
If you need me to be more explicit, it means
That's
I am
understand.
looking at a class 3 felony, and I am strongly in favor of putting people who steal this amount of money into prison.
He meant, yes, he understood.
Because I end up having to put people in prison every single day that have not had the advantages that you have had in life, that you still enjoy in this life, who steal a heck of a lot less, and they go to prison. And because you promised to make a payment of $127,000, you get the government to agree to give you a deferred judgment, and then you balk and renege on the main condition. I am not trying to make you uncomfortable. I am not trying to be unpleasant. I want you to understand exactly where you sit with me, with this court, and exactly what your situation is.
Maybe that's what they call counterfeiting these days, self-publishing. I love him too.
I'm pretty sure I ordered economic crimes supervision on this DJ. If for some reason I had not, I am ordering it now because I want an analysis from them. and over the next 180 days. Enter this deferred judgment on September 13th, 2021. Under 80 days from today's date. Is March 11th. And we're not going down to the wire on this. I'm going to set this for January 16th. For hearing on revocation. You continue to be on probation. You continue to be on the deferred judgment, but I'm going to set this for 1:30 in the afternoon on January 16th, 2026. And I realize that the 180 days is March 11th. But if we get to January 16th and there's still no payments, there's still nothing significant, there's still de minimis efforts, if there's still lack of complete payment, I think we're going to go forward with the hearing on January 16th, because the difference in this case, after 4 years and 4 months, is not the final 60 days. Your decision to think that you're going to save money for one lump sum payment was ill-advised and poor. To the extent that you can make payments regularly and get the money out of your account so that you're not just spending it, my friendly piece of advice is to establish a track record of payment. And the concept of substantial compliance or substantial ability as applied to you will be qualitatively different than somebody who grew up without your advantages. I will see you back on January 16th at 1:30 for the hearing on the revocation. And I really don't want to have that hearing. Good luck.
Thank you, Your Honor.
Deferred judgment is extended until March 11th, 2026. That'll work for you, Mr. Breckbuell? And if anything works out, I don't know what might happen, but if we're not actually going to go to the hearing, if there's going to be something not substantive, Mr. Azui will be here in person.
Don't
You
you
may appear
point,
remotely.
Judge. Get your hand
Thank
away
you, Your
from
Honor.
the camera.
You should just take your jacket off and take a look at it. Yeah. If I can call an FTA here, number 16, Miss Mail.
All right, 25 CR 1969, People versus Mail. You asked for it to be called up?
Yes, Ms. Mail's not here. They added themselves on after missing court, but I don't have any representations to make and I haven't seen them in court today.
All right, well, warrant's already issued. We'll note that they asked to be added on, and they have failed to appear. So
Thank you.
no other action on the case. Okay. We ready on McPherson?
We are, Your Honor.
Hold on a second.
She's sick. She is so sick.
We can go with the FTR. I mean, normally they're here. I don't know. Maybe they opted not to be here because of the motion that was filed,
How do we want to do this?
but we can use the FTR. All right, 23 CR 6533, People versus McPherson. Entries, please.
Anthony Santos and Jacob Friedberg for the people.
Jonna Stewart and Nathan Hall on behalf of Mr. McPherson, who appears in custody. Your Honor, is the court okay if Mr. McPherson and Mr. Hall sit at council table?
That's fine.
I don't know how you want to proceed with this.
Thank you for being here while you're sick.
Thank you. I'm masking so everyone doesn't hate me and get sick. If the court has trouble hearing me, just let me know and I'll try and speak louder.
Honey, we won't have that problem with you. We never do. You're sitting on
All right,
it,
I've read
Donald. Stand up.
Motion for a new trial. Reviewed the attached exhibits and reviewed the people's responses. One of the questions I had that wasn't real clear to me
You can get those remotes.
was
Look,
that
I can barely have to pause this, Judge, because he gives me all kinds of time to talk. You can get those remote covers that glow in the dark, and they partly work. Sometimes they glow. It helps.
at so Mr. McPherson's trial is June 22nd. Then, as the chronology is laid out in the defense motion, July 17th, well, June 17th, counsel for the co-defendant, Mr. Washington, endorsed 46 witnesses. And then after that, on July 17th, 8 new witnesses are disclosed through discovery. Were those 8 part of the 46 that were endorsed by the defense? Is that where the prosecution found out about these witnesses? That's a question for the prosecution,
Okay.
really.
Yeah, it's not for me.
That's my understanding, Your Honor.
I don't understand that representation. You're the prosecutor on the case. I don't understand your understanding. This is your case. The reason I ask is, having sat through both trials and having seen these witnesses, my impression was that the prosecution did not know who a lot of these people were. And it wasn't until defense counsel, through their investigation, well, not even their investigation, quite frankly, their client knows these people. Their client was able to tell them who these people were, that suddenly now these people are testifying. And my impression was that this was somewhat of a surprise to the prosecution. So that's why I'm asking the question. Did you know these people that were, these witnesses that were endorsed by Mr. Washington, or is this kind of like a pass-through thing that Washington does their endorsements? Now you have these new witnesses, you realize who they are, you can do investigation, and then they get discovered in Mr. McPherson's case?
And Your Honor, the second part is what happened, is the people that were disclosed per the defense endorsing witnesses that we previously weren't planning on calling.
All right,
Some
well,
of-
I understand the argument about not calling.
And
My
some-
question is a slightly different one. Were they known to you?
So one of the witnesses was in a message for the jail calls that was disclosed to defense. And so as far as they were included in any discovery, they specifically, what's that name? We did not know that any of these people had any information. We did not know if these people were there. So as far as the disclosure that the defense is talking about, or the defense is talking about, that disclosure was made once we had the disclosure by the defense in Mr. Washington's case.
And Your Honor, for clarification to the court, my issue is that the prosecution became aware of these witnesses on June 17th, prior to the start of Mr. McPherson's trial. The prosecution did not notify defense that there were potential witnesses that were new to this case. And from what I can tell of the timeline, is that they became aware of them on June 17th, and then it was July 19th that they were disclosed to defense counsel. That is after the trial had already concluded in Mr. McPherson's case. So I understand they were not endorsed under Rule 16. That's not what I'm arguing. I'm arguing is that what has become clear through, I think, or at least I was trying to make clear, is that there were a number of issues and things that the prosecution became aware of, that there were then consistent delays in disclosing to Mr. McPherson. And some of the information I became aware of because I attended the trial for Mr. Washington. I just received literally discovery today on this case. I will tell the court part of the information now that we have, the phone has now been discovered, and I had an opportunity.
Which phone?
Mr. Polar's phone. The actual data from that phone has been discovered. And in looking through that, it does appear that there is a phone number for the person who was identified as Brace as the female that was dropped off at the hospital with Mr. McPherson. We still have to do our due diligence to try and locate this person. But it's not just one issue. I think it's the cumulative nature of all of the delays and the information when it was known to the prosecution versus when it was disclosed to Mr. McPherson's team. I think the fact that we received a report that I did file as an attachment in Attachment A, which is the original report that was produced by Mr. Bradley, indicating that there were videos located on Isaiah Polar's phone.
I don't mean to be rude and interrupt, but I've read the motion.
Right.
I've heard the testimony. I heard the testimony, what he testified to in McPherson's trial, which was qualitatively different than what he testified to in the Washington trial. So factually and all that, I guess I don't need a
Right.
re-rendition.
And I'm not trying to go back into it, Your Honor. What I'm saying is, had we had the information that came out in Mr. Washington's trial, we would have absolutely gone into that issue in Mr. McPherson's trial. We had a report that indicated there was a connection between Mr. Polar and Mr. Washington. The court knows that it was a major issue in Mr. McPherson's trial, whether or not he had any connection to Mr. Washington. The prosecution made a large argument as to Mr. Puller being the getaway driver and the implication that he was involved in this. And the fact that we could not go into Mr. Puller's lack of connection, it's not just cumulative information. It's critical to the entire defense, which
All right, look, there are three issues that are brought up in the motion.
Right.
I was trying to get clarity on issue number one, which, three issues, the new witnesses. Two, there's the Bradley testimony. Three, there's the issue of whether or not Mr. McPherson, the jury instructions were going to allow. Now, there's two sets of instructions. There's the as a principal, and then there's as a complicitor. And we would be talking about the complicitor instructions and whether that would include self-defense as to Washington,
yes,
because McPherson had self-defense.
correct.
So anyhow, we have three issues.
Yes.
I don't want to blur them together.
Okay.
The first thing I was doing was getting clarification on the witness issue.
Okay. And,
So-
and I agree with the court. Those are the three main issues that are part of the new trial motion.
All right, so then what I want addressed initially, as we go through this logically, step by step, is first, as a prosecution contest what has been presented to the court as factual, that the prosecution would have received these 46 witnesses on June 17th. And it was not sent out for discovery until July 19th. Is that factually accurate?
We did not discover co-defendant Washington's witness list until that time, though it would have been publicly available to the defense, to this defense. I mean, it was just a document filed with court. So, I mean, I guess I don't entirely understand the court's question.
I just asked through the discovery process, is it accurate that this list was given to you, that you got the list on June 17th, and that you apparently, it says a motion at page 5 or paragraph 5 says McPherson did not receive notice of this. My presumption is they're referring through discovery. And so I'm just asking factually, did you discover this to them on July 19th?
I'm not sure that we ever discovered co-defendant Washington's list to them.
And Your Honor, for clarity,
On July 17th, there's a discovery packet that lays out A through H in paragraph 6. So that was done through discovery. Discovery packet 75, apparently.
Yeah, we in preparing for Washington's trial, looked at Washington's witness list and began to do our own investigation into who these people were, and then provided the information that we discovered on those individuals, primarily their criminal histories, and then a couple of memorandums of attempting to get a hold of them, and then one memorandum of a conversation that we did have with Ray J. McClellan. So to the extent that we disclosed any of these witnesses to defense in the McPherson case, it was by way of investigation into Washington's witnesses. I guess that's the confusion here. And it's pretty clear that there is no obligation on behalf of the people to provide this defendant with a list of the witnesses that another defendant intends to call, especially when we, at the time we received Washington's witness list, weren't even entirely sure who all of those people were, what connection they may have had to the case. whether they had any factual information or not. And we didn't know any of those things about any of these people.
Well, it's June 17th. You're also in the middle of preparation for trial for
Right.
trial that starts on the 22nd.
Right. So we hadn't even started looking into the Washington witnesses until we got through the McPherson trial and then started prepping for the Washington trial itself. And the fact that we may or may not, the fact that we were aware that these people had been endorsed does not create any sort of obligation under Rule 16 that we turn any of this stuff over to the defense. They're not our witnesses. We don't know who these people are. We don't know if they have any material information. And so there is no obligation on behalf of the people under Rule 16, under Brady, or any other case or case law that I'm aware of or that the defense has been able to cite, that we had any obligation to disclose to them what their co-defendant intended to do in terms of calling witnesses.
Ms. Stewart?
Your Honor, I would note to the court that the filings are public, or the court has access to the filings in Mr. Washington's case and can see that the filings were done June 17th. I think that
It's Don Quixote. I guess the judge loves Don Quixote, which makes sense for this judge.
question was not directly answered by the prosecution. We do have discovery packet 75 that was received on July 17th that disclosed the names listed in paragraph 6A through H in the defense motion. I would note to the court in paragraph 8 of our motion, it was on August 5th that the interviews took place, July 15th and 16th of attempting to interview these people. There was still a delay in getting that information in July to August, providing that to us. What has been consistent throughout the course of this entire investigation is that several people were not identified by officers at the scene, and we had made several requests throughout the discovery process and pretrial litigation to try and get the identity of these potential eyewitnesses. So I do think the fact that there are eyewitnesses that the prosecution becomes aware of, this is not something that completely blindsides the prosecution. They knew that there were several people that were associated with Mr. Washington. They became aware of that filing in June. They did not inform us that there may be additional witnesses that we would need to look into. And so we were not able to do that prior
Have
to
you
the
done it?
trial.
Have you done it since?
We have reviewed what is in discovery. We have not made contact with the individuals. I did see
Is
some
there,
of the
is there
testimony.
anything, is there anything that you received that you think would actually fundamentally change the trial against Mr. McPherson? Because I got to tell you, the witnesses that I'm presuming we're talking about that were not presented in the McPherson trial that did testify in the Washington trial did not testify favorably to Mr. McPherson. Their testimony was that it was Mr. Washington who's trying to calm everything down, and that Mr. McPherson, my words, not theirs, but he's the aggressive one. He's the one causing problems. He's the one, these are not, so even if they're assuming everything else for the sake of argument, that they should have told you, you should have known, you should have investigated. It sounds like from what I heard, none of these witnesses had anything positive to say that would have helped Mr. McPherson.
Well, I can't affirmatively say that. What I can say is that they have context for the circumstances that existed around the issue of self-defense, quite frankly, and whether or not
Okay, what is that context? So.
What was going
Art,
on?
I'm sorry, but look, you know the standard I have to apply. I have to make a finding that the newly discovered evidence is material to issues it involved. And yes, self-defense was a case, and that the newly discovered evidence would probably produce an acquittal.
Well,
So context to self-defense, I'm going to need more than that. You've read these
I
interviews.
understand. If the court will let me finish my sentence, what I'm trying to say is these witnesses would have been able to testify that there was no connection between Mr. Washington and Mr. McPherson. The prosecution argued that there was essentially an agreement because people went by a car. These were eyewitnesses who were present in the area around the time that the prosecution is saying this complicity theory evolved. Whether or not they're going to testify 100% in favor of Mr. McPherson is not the standard. The fact that the prosecution relied on a complicity theory, that there was no evidence in this trial that Mr. McPherson was directly responsible for any of the actual shots that resulted in the people passing. There was no physical evidence to link Mr. McPherson to that. They proceeded under a complicity theory. That complicity theory connected to a gang argument that because these people were gang members, that this was a gang-motivated situation about respect. These people that were disclosed in June would have potentially been able to be examined and testify to the fact that that's not what was going on. And that's the problem here is the prosecution wants to say, well, we didn't know about these people. We didn't know what they were going to say. The prosecution has gone forward on this theory that because a 10-second approach to a car at a different time than Mr. Washington is what establishes this agreement. That's what we're really dealing with here. And these other people were inside the club. They were able to observe the behaviors of Mr. Batts and the other bikers that were inside the club, removing these people in not the nicest of ways. There was a large group that the court could see on video. And whether or not everyone was calm and trying to, make everything okay, these were eyewitnesses to what was being said. The feel of the environment out there, that is all information in conjunction with contesting the complicity theory that goes into self-defense and the prosecution's theory. And so it's not a straight line of could they have answered questions 1, 2, and 3 in a certain way. It's the context of the entire evening that was going on. And so I do think that because they were present, because they knew who the different people were, there is information that would have been available to show that these two did not have a connection, that they were not acting in concert together.
If I may, Your Honor.
All right, well, we're not going to play ping pong. As to the new witness issue, anything else from the defense?
Beer pong, though, is still on the table.
Your Honor, I would note to the court that we have made diligent efforts to also locate the female that was in the car driven by Mr. Polar. We were unable to previously identify that person. It connects to the phone, so I'm trying to keep things separated the way the court outlined. But we are in the process of trying to locate this witness through a phone number. We don't have a name and address, but we can try with the phone number to locate. That is potentially another witness. This is evidence that the prosecution had in their possession and was not disclosed. That, I think, technically could be connected to a new witness issue. So I bring that up because it ties into the cell phone issue, but we are trying to locate that individual now that we have a phone number that connects to that person that became available, I believe, sometime in August. I'd have to look up when the full thing was actually provided. I'm blanking on the name of what the extraction's called. And I apologize, Your Honor, the phone extraction was discovered July 29th. It took us time to get it downloaded and then put it on a hard drive for me to have then access to.
Mr. Friedberg?
So Your Honor was referring to the Hopper factors found at 284 Pacific 3rd, 87 Colorado Court
She's
of
not
Appeals
crying,
decision from
she's sick.
2011.
She
And
has
it's
a
just
cold.
really important that we focus on what we're here to talk about, what the standards are. And so I had I'd answered the court's question, but I hadn't gotten into any of the Hopper factors. I want to do that now. That we discussed this in the motion as well. The first factor is was the evidence discovered after trial, unequivocally, and I'm only discussing these Washington witnesses now, because I'm presuming we're going one at a time. That's what the court seemed to suggest. So in terms of the Washington witnesses, we did not know that any of those people had any material information until after the trial. The fact that we were on notice that the other co-defendant intended to call them is totally irrelevant, because at the time, and to be honest, looking at the list, I'm still not sure why some of those people were endorsed, because most of them wouldn't talk to us. I still don't know if some of those people have any relevant information. We looked them up because those were the people identified on the Washington endorsement that we weren't aware of, that we didn't already know of. So any information substantive to the case as it relates to those witnesses was discovered after the McPherson trial. Prong 2, the defense has just completely ignored. And that is, did the defendant and his co-counsel exercise diligence to discover all possible evidence favorable to the defendant prior to and during the trial? Nobody has talked about this at all. What did the defense do to try and identify any of these people? What steps did they? Can't just say, yes, we were diligent. They need to make a record about what that diligence was. And it could have included like just asking co-defendant, hey, do you have any of those people's names? Do you know who any of these people were? The record is completely silent on what steps the defense took prior to trial or during trial to identify any of these people. And then what they have acknowledged since is that they've done essentially nothing to follow up on any of these people other than read the memos that we created. And they've had months to follow up and to do their own investigation, their own interviews. None of that's happened. So there's been no diligence at any point to identify who any of these people were on behalf of the defendant or on behalf of his counsel. And that is one of the factors that you need to consider. And then 3, the newly discovered evidence is material to the issues involved. We're talking about eyewitnesses, so I'm not going to spend a whole lot of time on that. I certainly disagree with the way that Ms. Stewart couched the materiality here. And I think that it's better discussed within prong 4, which is on retrial, will the newly discovered evidence probably produce an acquittal? And so it is a straight line. You have to look at what do these people have to say, and would it be helpful to the defendant, and not just hypothetically so, not just maybe sort of so, but is this evidence strong enough that it probably would have changed the entire outcome of the case? It's a very high burden, and it's because these sorts of Monday morning quarterback motions are looked at with disfavor. And so, what we need here is kind of the smoking gun that would have changed everything. We do not have that here at all. And Your Honor is absolutely right. What the two witnesses that did testify that had anything substantive to say actually said was, everything is that guy's fault. He was the initial aggressor. He shot first. And there's nothing about any of that that is helpful to the McPherson case. And there's nothing about any of that that would suggest that there probably would have been a different outcome. We already had that testimony in large part from Manuelito Vigil, who said the same thing. And so the complicity issue is really secondary to, I think here, entirely to who the defendant was, what his role is, and who shot first. Right? Initial aggressor is really the issue here. And there's nothing about what we learned subsequent to this trial from those witnesses that would probably have made a difference. And so we have serious problems with prong 2 and prong 4. This argument related to the Washington witnesses should clearly fail.
Your Honor, I can make a record about due diligence.
It's hard to believe he was a lawyer because he doesn't immediately start talking when it's his turn. Maria,
All right, that's
hi.
prong 1, defense reply.
Your Honor, prong 1 is
No,
that it was discovered
argument
after
1.
trial.
Right, argument 1, the witnesses.
Your Honor, and I'm sorry for, you said prong 1. Are you wanting me to go into that it was discovered after trial?
We are currently arguing in sequence the 3 issues brought up in your motion.
Okay.
You have made your argument as to argument number 1, the new witnesses. The prosecution has now responded. I am asking for your reply.
Okay. Your Honor, as to the new witnesses, we did make efforts to locate this information prior to trial. We spoke with the prosecution several times to determine if they were able to identify anyone. We tried to identify people through video surveillance, through looking for people in social media. We did ask Mr. Washington's counsel for names of witnesses. They declined to provide that to us. I asked on more than one occasion if they would be willing to share with us if they had any eyewitnesses that they could disclose. They said no. The fact that these were filed with the prosecution puts them on notice on June 17th that there are potential witnesses. Our trial happened the following week. They did not indicate in any way, shape, or form that they had new potential names, even if they had not been investigated, that the implication was that these were people who were potentially present at the scene. We know from the video evidence that there was a large group of people that Mr. Washington was.
Okay, let's be
associated
careful
with.
there. Do we know that?
We know
They
that
got endorsed names, but with the endorsement is just a name and address. It doesn't say this person was there. These could all be character witnesses as far as the prosecution knows.
that they could be, but the court also has information and the prosecution had information that the argument always was through the discovery and the investigation that Mr. Washington was responding to his daughter, who was present at the club with a group of her friends. That is,
I'm just trying to make sure the record's clear. Your argument is that the DA knew or should have known that these people were there, but I don't think that's,
my argument is that they became aware of new witnesses related to the trial prior to the start of our trial.
they became aware of defense endorsed witnesses.
Yes.
Yes, okay.
That they did not disclose to us. Part of the factor is whether or not it happens prior to trial. My argument is they became aware of those names and did not disclose them. Second to that is we did exercise due diligence.
I think this is the one, we've been following this one a little bit, guys. We've seen some of the earlier hearings for this one. This is the one where the daughter was in the club. The father is part of a biker gang and came to the club to help his daughter. And then I think there was a huge fight broke out, and it looked like on the camera the dad was trying to, stop the fight, calm everybody down. But then the dad goes and gets a gun. And they're trying to say that, he didn't get the gun to hurt anybody. It was for crowd control or whatever. I think that's this. This could be a different one.
We have repeatedly requested discovery in this case. There have been repeated issues about information being turned over and turned over timely. As it relates to those witnesses, we did not become aware of them from the prosecution until, I want to make sure I'm correct on the date, sorry.
All right, Peg Leg.
July
So,
17th in
All right.
Discovery Packet 75.
all right, Peg Leg. There's a club. There's a fight at the club. And there's 13 people involved. Or there's 13 people in a group around a fight. Let's say four out of the 13 are actually swinging. All right, but the other 9 are like yelling and pushing and trying to hold each other back. Okay? Does the prosecution have to talk to all 13 of those people? Because is it Brady or the law that they have to talk to all 14 of those people, or can they just talk to the 4 that were fighting and call it a day?
It was then discovered on August 5th of 2025. Summaries of investigations done. Those interviews were done on July 15th and July 16th of 2025.
Martha, thank you for the bits. I
As I
appreciate
stated
it.
in my
Thank
motion,
you.
that's nearly a 3-week delay in providing this information. In addition to, even if the court says they didn't know who these people were on June 17th, they did become aware of who these people were during the course of their investigation. There was a delay in getting that to us. I don't know if the court wants me to repeat my prior argument as to the complicity, saying that's a secondary factor. Again, there was no direct evidence that Mr. McPherson was the person who is responsible for directly shooting the victims in this case. They went under a complicity theory that because he shot first and other shots were fired, that they were acting together. the information that this would potentially result in a different outcome, the court has in the other trial, they did not come to a jury verdict on counts 1 through 4. Breaking this up, I know logically makes sense on each issue, but when the court looks at the totality of all of this, the trial and the information that was heard by the jury was different in Mr. Washington's case for a number of reasons. That different information in its totality had a different outcome. It's not very often where you have a situation where you can actually point to another jury listening to similar information and coming to a different result. So I do think as it relates to the other witnesses, and in paragraph 6, that the court heard enough information about them being present and the jury heard enough information about them being present and the circumstances that surrounded it, that the result was different.
Thank you, Kelly. Thank you for the
I
bits.
don't want to
Thank you.
repeat
Thank
myself
you.
because I know the court's seen the motion and heard me already argue previously. If the court has specific questions as to the witnesses, I can address those.
All right, as to your Bradley testimony argument,
Your Honor, as to the Bradley testimony, we relied on the information that was in the report. We attempted to interview Mr. Bradley. He refused to meet with us. That's his choice. That's his right. We reached out to the prosecution to see if they would be able to help facilitate meeting with any of the experts. They said it's up to the experts on whether or not they meet with us. I agree with that. But we did make efforts to speak with him prior to the testimony. We made a strategic decision that based on the information that was contained in his report, that Mr. Puller had viewed 2 videos of Mr. Washington and Malia Hill, that we were not going to go into that because we didn't know if Mr. Puller would actually show up on his subpoena. We had done our due diligence in our investigation and had information that Mr. Puller would be able to explain that he had not viewed those videos. We had to rely on the information that was presented to us by the prosecution because that's what we had. We could not go into the fact that there was not a connection with Mr. Bradley because he testified that he reviewed a cell phone and that information was on there.
and just so that we're clear for the record, we're talking about a connection between Washington and Puller.
Correct. And in the court's trial with, or in the jury trial with Mr. Washington, Mr. Bradley testified that there were 2 videos on Isaiah Puller's phone that showed Mr. Washington and Miss Hill. That happened on, I think it was the 25th on Friday. Then over the weekend, co-counsel on that case asked for the extraction because they realized they didn't have it. On Monday, the 28th, the court heard argument about what the issue was with the phone. Had it ever been reviewed? Had it not been reviewed? Was the information incorrect? I know in the prosecution's motion, they say I didn't pull the transcripts, which is inaccurate. I ordered an expedited transcript for the 25th of July and the 28th so I could understand fully what had happened. The court found that the testimony that Mr. Puller had viewed videos of Mr. Washington gave a 1 degree of separation between Mr. Puller and Mr. Washington.
I'm 7 degrees from Kevin
The
Bacon.
prosecution argued that Mr. Puller was the getaway driver and they insinuated that he was involved in all of this. The fact that the report of Bradley was wrong is huge. Like, how can we not need to go into that to show that there's even more of a removal of knowing people when Mr. Washington and Mr. Puller don't know each other. And there's no evidence that they did. The prosecution chose not to go into it. I don't know why. We relied on the evidence that was presented in Bradley's report for that trial. I can tell the court, if we had the information we have now, we absolutely would have gone into the fact that there was no connection between Mr. Puller and Mr. Washington. And the court knows I spent a lot of time in trial going through the lack of connection between Mr. Washington and Mr. McPherson. It cannot be understated how important it is to be able to say that there is no connection between Mr. Puller and Mr. Washington. Again, under the complicity theory that the prosecution moved forward on, this and the gang evidence was that because these people are gang members, that they were acting together. This would have shown that there is even less evidence to support that. And it would have been it's not cumulative, it's critical to addressing this third party that the prosecution argued very, very heavily was involved in this. And we made efforts to review all the evidence. We went to the property view. We reviewed all of the information that we had in the files. We have lengthy email chains between the parties trying to make sure that we have all of the discovery in this matter. And we were told and assured we had everything that they had. And then it comes out that there's an entire phone extraction with conflicting information. And that doesn't come out until well after trial. That comes out nearly 30 days after Mr. McPherson proceeded to trial. So as far as prongs 1 and 2 goes, that it absolutely without question happened after the trial. We were making every effort we could to interview the witness, to review the information that was provided, and to make sure that we had all of the information provided through discovery. We were assured we had it. Being able to argue the lack of connection between Mr. Puller and Mr. Washington was critical to the defense of Mr. Washington or Mr. McPherson. And I put in my motion, the court knows, because you were present when that testimony was corrected, the first thing that happened was one of the jurors stood up and asked the questions. To be clear, there's no connection between Mr. Puller and Mr. Washington, and there's no connection between Mr. McPherson and Mr. Washington on the phone. That was a jury question that was asked directly after the clarification occurred. It shows the importance of that information to a jury's consideration. And again, in the Washington case, when the information was clear that between the three of them, there was no connection through the phone or through social media and the street checks, the jury came back with a hung verdict. They did not come back with the convictions on count 1 through 4. So I do think that the court has very clear information as it relates to the phone, that information was critical, and we were prevented from going into it because of the misinformation in the report. And I think it goes to Mr. Bradley's credibility. He's an investigator that looked through all this information, and he was incorrect. And I think a jury has the right to know that.
Mr. Freeberg?
Well, again, Your Honor, we got to go through the prongs. The evidence was discovered after trial. I think that prong 2 is a little a little bit of more of a close call. We recognize that the phone dump was not discovered. It remains our position that the phone dump of a third party that that was charged, obviously was no, and then those charges were dismissed by the court, is questionably Brady material in the first place. Or it's questionably Rule 16 materials in the first place. There's nothing on any of the phones that suggests that there's any sort of Brady material there. And so I don't mean to diminish our failure to provide that, though I don't know that there is a Rule 16 issue there, and that's not what we're really here to discuss. At the same time, I think what we do now after trial, looking back, is different than what we do before trial looking forward. And what prong 2 here suggests is the onus really needs to be on the defense, right? And they have to show diligence. And I recognize that the argument here is that, well, we took the people at their word, and they should, but they also never looked at the phone themselves or asked to look at the phone to confirm any of what was in Mr. Bradley's reports. And so I'm not sure that we've exercised diligence here. And I'm also not sure that they've done anything to demonstrate diligence since then, because I don't know that there hasn't been any sort of record about whether or not they've looked at the phone since, and if there's anything on there that's helpful, because I think Bradley's testimony and the phone are really kind of all part and parcel of the same argument here. What I can tell the court is that while there is not connection, there's not evidence of a connection on the phone, because we've looked at it now, between Puller and Washington. There's ample evidence on the phone of a connection between Puller and McPherson. I'll get back to that here in a second. And that obviously was the focus on during the McPherson trial was on McPherson. That's why we didn't get into Washington and connections between Washington and Puller. It was really questionably relevant to begin with. But I'm not sure that they have established that they exercised diligence to discover all possible evidence favorable to the defendant prior to and during the trial. Now, 3 is a far more interesting question here. Is the discovered evidence material to the issues involved? And along with that, again, would it probably have produced an acquittal? So we got to break down the defense's argument. And the last argument was, well, it would have helped us to cast doubt on Bradley's credibility and impeach him. But the problem is that the case law says that is patently, clearly not sufficient in order to establish either of these last 2 prongs. The Colorado Supreme Court has told us as much in Farrer v. People that's cited in our motion, that in order to satisfy either of those prongs, the evidence has to be of sufficient consequence for reasons other than the ability to impeach, which is the whole argument. We would have really liked to have been able to impeach Mr. Bradley. Well, that's not good enough. To cast doubt upon or cast doubt upon the evidence already presented at trial. So just saying that we think that we could have made a better argument, we think we could have impeached witnesses better, that there may have been kind of a shadow cast on the witness or the evidence, patently not good enough. And so we fail both of these. But then there's better argument, or there's better language still within that same case that talks about the evidence has to be consequential in the sense that it is affirmatively probative of the defendant's innocence, whether that's accomplished by helping to demonstrate that someone else probably committed the crime, that the defendant probably could not have committed the crime, or that the crime wasn't committed at all. That's the standard that the court has to look at when you're weighing these last 2 factors. And we're nowhere close to that with any of this. And what happened in the Washington trial and the hung jury there is is patently irrelevant. My understanding is the majority of the jurors there were voting to convict. But more importantly, they were looking at a completely different individual who had a completely different involvement. Do we still believe that the two were acting in concert? Absolutely. But their actions and their parts in all of this are consequentially different. What the evidence shows, and what even the newly discovered Washington witnesses that the defense talked about before, and I don't mean to cross the streams here, but still clearly suggest is that this man shoots first. That is the most powerful evidence that was.
I guess I agree. He did shoot first. That's not up for debate. Monica, thank you so much for the bits. I appreciate it. Thank you. I don't know how much longer this goes on, this part right here. So I'm going to cut it off for today. And we're going to jump right back in it tomorrow. That way, because I'm not sure. The judge is loving this. He is loving this. When there's tough law questions, the judge just is in his glory. So he's not the one that's going to give an answer right away. He has to think about it. But we will get an answer tomorrow about what to do with these things, I think. I'm pretty sure. Unless that's a different case that's like this that's coming right after this. But I'm going to start OJ. So I will, you'll see him smile. Don't worry, Kelly. You're going to see him smile. Is the screen frozen? Nope. Just stand up. Yeah, you got to find the remote because I'm going to start OJ. I'll see you all later, though. I hope you all have a great day. Thanks, guys. Bye.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me with such a group. Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me with such a groove. I'm less lonely. Oh, Kathy's the creator. She's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy